Do fair housing laws require that I rent to the first qualified applicant? Fair housing laws do not tell you how to pick applicants, except to say that you can't refuse to pick applicants based on a protected special trait. The safest and best practice, however, is to decide your rental qualifications in advance and be sure those qualifications are objective. Landlords may use objective qualifications to select applicants that include income level or ability to pay, good credit record, no previous evictions, and references from previous housing providers. You can base your final decision on time of receipt, the first application you receive from someone who meets your qualifications, or credit score, qualified applicant with the highest credit score, or income, qualified applicant with the highest income, or any other criteria that has no relation to a protected special trait. What factors are not okay to consider when deciding who to rent to? You can't ask applicants whether they are citizens, legal residents, or undocumented immigrants. You also can't ask questions about protected special traits. For example, you can't ask applicants about their disability. California law says you can't ask whether an applicant is married or gay. You should not make assumptions about applicants based on their race, religion, or other protected special trait. For example, you can't refuse to rent to an Indian family because you think they will cook with curry and cause strong cooking smells that will bother other tenants, or refuse to rent to a Mexican family because of the stereotype that they will move in their relatives without your permission. How can a housing provider determine if an individual poses a direct threat? The Act does not allow for the exclusion of individuals based upon fear, speculation, or stereotype about a particular disability or persons with disabilities in general. A determination that an individual poses a direct threat must rely on an individualized assessment that is based on reliable objective evidence, e.g., current conduct or a recent history of overt acts. The assessment must consider 1. The nature, duration, and severity of the risk of injury, 2. The probability that injury will actually occur, and 3. Whether there are any reasonable accommodations that will eliminate the direct threat. Consequently, in evaluating a recent history of overt acts, a provider must take into account whether the individual has received intervening treatment or medication that has eliminated the direct threat, i.e., a significant risk of substantial harm. In such a situation, the provider may request that the individual document how the circumstances have changed so that he no longer poses a direct threat. A provider may also obtain satisfactory assurances that the individual will not pose a direct threat during the tenancy. The housing provider must have reliable, objective evidence that a person with a disability poses a direct threat before excluding him or her. What should I do if I discover that one of my tenants has harassed another tenant because of a protected special trait? Tenants sometimes have disagreements with one another, and you may feel like those disagreements are not your concern. As a housing provider, however, you must step into a disagreement if one tenant is harassing another tenant because of a protected special trait. This could happen if certain tenants are bothering tenants with children because they don't like being around children, or because they don't like other tenants' religion or race. This is discrimination, and you must take action as soon as you know there is a problem. When your tenants tell you that they are being discriminated against by other tenants, you should do what you can to investigate the complaint. One way to investigate is by talking to anyone who may have seen what happened to the complaining tenant or to the neighbors of the tenants involved. You can also ask to see any notes, text messages, or other documents that might verify what happened. If you decide that the complaint is true, you must take some action. An action may include warning tenants who are harassing and discriminating against other tenants, giving them a notice, or even evicting them. It is always a good idea to let your tenants know up front that you will not put up with any discriminatory behavior. However, you shouldn't evict tenants involved in the disagreement without trying to investigate the discrimination complaint. You should be especially careful in dealing with noise complaints about families with children or people with mental disabilities. When you receive these complaints, make sure that the tenant who is complaining is being reasonable and try to determine whether other tenants agree with the complaints of excessive noise. If the tenant who is complaining just doesn't like children or feels uncomfortable being around someone with mental disabilities who may act and sound differently, then he or she could be discriminating against those tenants by complaining. Moreover, if you take action against the tenants who are being complained about, without seeing for yourself whether the complaint is true, you could get in trouble for discriminating too. Why would a property manager refuse to rent to a handicapped person? A landlord or property manager could refuse to rent to a handicapped person with a 580 FICO score, as stated in the previous section, as long as you are consistent, and would not rent to anyone below a certain FICO score. The challenge might occur when you keep turning down potential tenants with sub-600 scores, and finally, the landlord gets frustrated and asks the agent to lower the bar to 575. If that occurs, assuming you kept good records, it would be best to go back to every potential tenant who recently applied and see, and they are still looking for a property. Assuming all other criteria were acceptable, it would be best to approach the previous applicants in the order that they applied and offer them the chance to rent the property. Once the first one says no, move on to the next one. Doing this protects you from a potential discrimination charge if one of the previously denied applicants was a member of a protected class. Must a landlord or property manager to rent to a convicted felon? No, since felons are not a protected class, and a convicted felon could pose a risk to other tenants. A family of 7 in a 2-bedroom condo? No, since that number of persons probably exceeds the county health limit. A handicapped person with an assistive animal? Yes, even if you have a no pets rule. Assistive animals can be almost anything, but not pets. Note, as long as you are consistent with your no pets rule. Say an applicant has 3 cats as pets, the landlord could have a no pet rule even with a handicapped person. Thus, you could not deny renting to that tenant based on the assistive animal or that they are handicapped, but could deny renting to them based on the 3 cats as they would be considered pets. Be fair and equitable in your treatment of people. Treat everyone the same. If you provide more service and benefits to one and not the other, you could be guilty of discrimination. Your level of service should not change based on who the clients are. Be consistent in your requirements. If you begin working with buyers and treat all of them the same, there is no problem. If one buyer is asked to complete an application, obtain pre-approval, and provide a credit report, and the next buyer is not asked for those items, then you could be guilty of discrimination. Don't discuss issues such as who lives in a neighborhood, who lived in the house, etc. Often clients will put you on the spot and ask you if any of those people live in the area. Even if you know the answer, you cannot and should not discuss that with a client. Put them on notice, meaning tell the client that you are forbidden from discussing that question and that you would appreciate it if they did not ask any such question again. Certainly, that might seem combative or non-cooperative, but you really have no choice. Clients might challenge you further and question your honesty or integrity. Don't take the bait. Don't allow them to humiliate you or goad you into answering the question. Stick to your guns and tell them no. If they insist and continue to humiliate you, you might need to decide if you will continue to work with them. This conversation takes on a different meaning when you market yourself as the area expert. Being such an expert, a potential client might challenge you and demand information on the racial makeup of the neighborhood. It becomes more difficult to say that you don't know when you are the expert. Thus, it becomes more important to answer as we discussed above, that federal law forbids you from discussing such an issue. What if a client asks what appears to be an inclusive question, meaning they ask you where something is located that they want to be near, such as a Mormon church, a Jewish synagogue, or a Latino food market? You are allowed to identify landmarks, structures, or other properties as something they might want to be near. Draw a 1-mile circle around it and show them every available property in that circle. So, you may conclude that you may be inclusive, yet not exclusive. If someone wants to be near specific locations, you may help. If someone wants to be away from certain people, you may not address that issue.